Subject, urgent matter, allegations of fraud and custody issues, 3-year situation, to whom it may concern. My name is Michelle N. Olson, and I am a proud 31-year-old mother of 2 extraordinary children named Ivy Quinn Olson and Lila Mae Olson. I am writing to bring to your attention a deeply troubling situation that has been ongoing for 3 years now and has left me desperate for help. I have been tirelessly seeking the right channel to address this matter, including reaching out to the Butte County District Attorney's Office, but with no success in finding a resolution. I am reaching out to you because I am running out of time, and I fear for the well-being of my children. I cannot allow my sister to take off with my children and potentially adopt them, severing all ties between them and their families. My children's safety and well-being are at stake. If you are unable to assist me directly, I kindly request your guidance on the appropriate steps I should take to address this urgent matter. The crux of the issue revolves around my sister, Christine, who has obtained custody of my 2 minor children through fraudulent means regarding a severe violation of my parental rights as well as fraudulent documentation orchestrated by my own sister Christine Olson, Lure, and the North Butte County Courthouse. In brief, my ordeal commenced during a crisis when my children were taken out of state by my youngest daughter's father David Green, who was subsequently arrested for child stealing. In my pursuit of temporary assistance for my children during their absence, I unwittingly consented to a caregiver's authorization without fully comprehending its implications and relying on my sister's word, for I did not understand and trust her. Regrettably, my sister clandestinely contained legal guardianship for my children by falsifying consent forms GC-211 at the North Butte County Courthouse. I firmly believe that she has committed acts of forgery and fraud to gain custody of my children. Her actions specifically, she forged my signature on a GC-211 consent and waiver of notice form back in August 2020 without my knowledge or consent. Our shared father Michael Olson and I had reported these fraudulent activities to Officer Passmore of the Butte County Police Department. Upon my discovery of my sister's ulterior motives, I physically appeared in court on the day she acquired legal guardianship of my children on November 30, 2020, vehemently opposing the proceedings. To my dismay, the presiding judge Claire Keithley disregarded my objections despite there being clear evidence of signature forgery. The judge dismissed my objections and unfairly asserted I was late and declined to hear my side of the story. Even before the guardianship order was formally established, since that day I was systematically denied a voice and ignored entirely by the courts regarding my concerns. As a result of her actions, I have not seen my children for nearly 3 years and have had no communication with them for an extended period. Furthermore, Christine obtained a fraudulent domestic violence restraining order, DVRO, against me, which has been in effect for 3 years. This DVRO has prevented any contact or communication between me and my children, despite my unwavering assertion that I have never engaged in the alleged misconduct. This situation has caused immense pain and suffering for me and, more importantly, for my children. The circumstances surrounding the DVRO raise serious concerns. I was given incorrect information regarding the hearing time, which resulted in me missing the hearing by a mere 10 minutes. This misunderstanding was compounded by the fact that I live 5 hours away from the court. Consequently, the DVRO remains in effect, unjustly preventing me from seeing my children. My children and I shared an incredibly close and special bond from the moment I learned they were growing inside my belly. I devoted every moment of every day to being a full-time mommy to my 2 best friends and my children, and I cherished every second of it. We lived a joyful, productive, and meaningful life together. Life felt perfect with my children by my side, and I never once imagined that everything could change in an instant. In the blink of an eye, I went from seeing their beautiful faces every single day, feeling their hugs, hearing their voices, laughter, and the pitter-patter of their little feet on our hardwood floors in the morning. I would eagerly await the moment when they'd burst into my bedroom, climb onto my bed, and playfully wake me up, unaware that I was pretending to be asleep. I never thought I would fall to my knees in a grocery store at the sight of a toy or the laughter of another child. I never imagined I would be unable to get out of my vehicle or that the silence around me would be deafening. Every day now feels like it's in slow motion, and the simplest tasks, like getting out of bed, are painful. I never thought I would be unable to step into my own backyard because the memories are too painful to bear. I am a 31-year-old mother whose children have been wrongfully kept from me by my own sister. She has concealed the true monster within her behind a facade that deceives everyone she encounters. I trusted my sister, believing she would keep her promises and protect my children from harm. Due to this misplaced trust, I have not seen my children since my eldest, Ivy, was 6 years old, and my little Lila Mae was 3 years old. I have not had the privilege of speaking with my children for nearly 2 entire years, for reasons known to no one. This has been unjustly taken from my children, our family, and me, all because of my sister, Christine Marie Olson. I know I'm not supposed to get emotional, but this is a very real situation. I dare anyone in my shoes not to shed a single tear. I've cried millions of tears, feeling like I cannot save my children and that I am missing out on their growth and development. Every day, I wonder where I have gone and why I left them behind, not knowing the truth because Christine Olson will not allow the truth to come forth. She has completely isolated my children from their familiar homes and people they've always known. I'm sorry, but it is almost impossible not to get emotional about this, especially knowing that I'm not allowed to do anything about it. I can't hug them, tell them it's okay, or even know where they are located. I don't know what they look like, sound like, or what they've been up to, and it's all for no reason whatsoever. This situation has been unjustly taken from my children, our family, and me, and it is a fact beyond words and imagination. How could anyone consider this okay? How was I ever viewed as such a bad person, having less privilege than a child abuser or worse? I have no forms of contact for something I haven't done. I have no chance to defend myself, no fairness in this case, and my children have been taken from me. Not one person with the authority to bring them back to my care and do the right thing has even bothered asking for my side of the story. The best interest of my children is not being considered here. If this is what the courts are looking at as the best interest of children, then they themselves need to be seriously evaluated. I went from spending every waking moment with them to not even being allowed to hear their voices or see their faces. I am left in the darkness with no knowledge of where they currently reside. No one informs me about my children, and I am left in this heart-wrenching situation for no discernible reason. It's all due to my sister's selfish and dishonest actions and the court's failure in Butte County to pay proper attention and fulfill their responsibilities. This court has effectively awarded custody to my sister without any prior notification to me, effectively erasing my existence and significance in my children's lives from the very moment I discovered the court's involvement. I will not give up and be forced to give up on my children by any means. This entire situation is far from normal, and even with no prior knowledge of the courts of law, I can guarantee there is something not right, something suspicious throughout this entire process. It raises concerns of neglect, misconduct, or perhaps even corruption. This court is not inspiring confidence or trust. There were several issues with the November 30th, 2020 hearing regarding the contesting of the guardianship by David L. Green, the biological father of Lila Mae Olson. 1. Lack of legal assistance opportunity * just 2 days before the hearing, which happened during the Thanksgiving weekend, I attempted to meet with David to understand his perspective on the situation. However, due to the holiday, I had no opportunity to seek legal assistance or advice. During this meeting, David shared the investigator and social worker reports and recommendations from August and September 2020. These reports contained erroneous and degrading statements made by the guardian, my sister, the investigator, and social workers. Notably, these reports contained false claims, such as the assertion that I had heavy meth usage during one of my pregnancies, for which there was no evidence. 2. Concerning discovery * upon reviewing these reports, I was shocked to learn that my sister, who I believed was helping my children as a temporary guardian, had different intentions. Her intentions appeared to be the opposite of what I initially thought, as she had made damaging statements about me. If David hadn't shown me these reports, I might not have attended the court hearing, as Christine had provided various excuses to deter me and my mother from attending. However, I still attended the hearing, albeit late, due to a navigation error. 3. Contesting guardianship and signature forgery * upon entering the courtroom, I immediately contested the guardianship and alleged that Christine had forged my signature on GC 211. However, the judge disregarded my claims and stated that she would not entertain my arguments because I was late for a hearing I didn't even know was mandatory for my attendance. 4. Unequal access and visitation rights * during the hearing, it was decided that David would have more extensive access to Ivy, despite him not being her biological father, while I was granted limited contact, only 1 call per week and physical visits at the discretion of the guardian. 5. Inaccurate assumption regarding David's consent * the judge, Claire Keithley, stated that David had consented to the guardianship, but he had not signed the GC 211 form. If he had signed it, he wouldn't have been served in person by a police official since GC 211 involves consent and waiver of notice. However, the judge made an assumption without investigating this matter further. 6. Allegations of signature forgery * I separately stated in court on November 30th, 2020, that Christine had forged my signature on the GC 211 form. This serious allegation should have prompted further investigation by Judge Keithley. I have serious concerns regarding the actions and behavior of the court investigator, Julio Quiñones. I wish to address a series of deeply troubling events related to the conduct of the court investigator, Julio Quiñones, in my case. These events have raised serious concerns about his professionalism, integrity, and impartiality. Firstly, Mr. Quiñones failed to adequately investigate a domestic violence restraining order, DVRO, event that supposedly occurred. It is puzzling that he did not make the effort to contact the facility where this incident was said to have taken place. However, he did contact them when it came to obtaining a statement from the therapist regarding my contact with my children. I would like to see proof of this statement from the therapist, as Mr. Quiñones' reports and recommendations do not support the claim that my children and I have no contact. Furthermore, if it were indeed the case that my children and I should have no contact, why would the legislator assert that it is in the best interest of children to be in frequent and continual contact with their parents? This inconsistency raises concerns. Secondly, I've noticed a pattern in Mr. Quiñones' reports where he claims to have difficulty contacting individuals who play vital roles in my case, such as Lila Mae's therapist. It's puzzling to me that he would have trouble reaching a therapist, who one would assume frequently answers calls and returns messages, especially those from a court investigator. This raises questions about whether Mr. Quiñones made genuine efforts to contact these individuals or if there were other reasons behind his purported inability to reach them. For example, he mentioned having difficulty contacting Mr. Lure's mother and the alleged victim of sexual abuse/molestation, which are critical aspects of the case. Moreover, during a meeting in March 2021, Mr. Quiñones told me that he had attempted to call me numerous times without success, suggesting that there may have been an issue with the contact number he had on file. However, when he dialed my number in front of me during that meeting, the call went through without any issues. This raises questions about his credibility and whether he made legitimate attempts to contact me. Mr. Quiñones' behavior also raises concerns about his impartiality and integrity in handling my case. He expressed doubt that the judge would terminate the guardianship, indicating that he did not believe in the possibility of a fair outcome. He also advised me not to bother bringing binders of evidence, as he believed the judge would not consider them. Perhaps most concerning is Mr. Quiñones' breach of confidentiality. He discussed my private concerns and requests with the opposing party, Christine Olson, which jeopardized my child's safety and undermined the integrity of the investigation. This lack of discretion is deeply troubling. The top event I would like to highlight occurred and Mr. Quiñones produced a report and recommendations for the court without ever speaking with me or informing me of the court's involvement in my case. I was completely unaware of the court's actions because Christine, the opposing party, continued to communicate with me regularly as if everything were normal. She never once mentioned her actions or intentions in this matter. Furthermore, the former court investigator, Julio Quiñones, had never contacted me before issuing his reports, which contained false and damaging accusations such as being associated with a violent fugitive ex-boyfriend wanted for suspected armed robbery and murder. He also alleged that I used drugs during pregnancy and while parenting my children, leading to cognitive delays in my children. It is crucial to note that all these allegations were entirely baseless and untrue. Astonishingly, the court accepted Quiñones' report without proper scrutiny or investigation. Adding to the injustice, the appointed guardian unlawfully severed all contact between me and my children just 1 month after the court order, despite her knowledge of my whereabouts and her false claim that I was unresponsive. The court severely restricted my visitation rights for 3 years, granting privileges and access to individuals with concerning backgrounds, including David Green and Joshua Ludwig. Moreover, when I exposed the guardian's dishonesty about her arrest history, the judge attempted to label me as a vexatious litigant, threatening repercussions if I dared to raise the issue again. This is despite the fact that her deception should have resulted in a misdemeanor charge by law. It was instead weaponized against me. The court investigator, who came under investigation due to my complaints, promptly retired after a 3-month investigation. The only other investigator in the entire courthouse also retired, raising significant suspicion. Additionally, the self-help clerk handed me a human trafficking pamphlet and encouraged me never to give up on my children. When I began highlighting the court's errors, they transferred and consolidated the cases with the LA County Court. In retaliation, the guardian filed for my children to be declared free for adoption, effectively closing the Butte County case. Unfortunately, the LA County case lacks records of this transfer and consolidation, as such cases are not typically consolidated, and it lacks access to the probate case. In the reports that Mr. Quiñones prepared without proper investigation or prior communication with me, he made assumptions and false statements against me. These statements were not only deeply offensive but also highly degrading, disgusting, and, most importantly, untrue. His reckless and baseless accusations have caused significant harm to my reputation and well-being. Furthermore, Mr. Quiñones' failure to engage in a thorough and unbiased investigation has undermined the integrity of the entire legal process. His actions have left me feeling unheard and unfairly treated by the court, as he failed to provide me with an opportunity to defend myself against the damaging allegations he included in his reports. These events have left me with serious reservations about Mr. Quiñones' competence and suitability as a court investigator. His lack of proper communication, impartiality, and investigative rigor have cast a shadow of doubt over the proceedings. I urge you to thoroughly review these concerns and take appropriate action to ensure a fair and just resolution to my case. I am writing to address a significant violation of my constitutional rights under the Due Process Clause of the 14th Amendment of the U.S. Constitution in the handling of my case. The Due Process Clause of the 14th Amendment safeguards a parent's fundamental liberty interest in the care, custody, and management of their children. However, in my case, I was denied the opportunity to be heard at a meaningful time and in a meaningful manner regarding the issue of legal decision-making authority related to guardianship being granted, whether temporary or permanent. Due process mandates that parties involved in a dispute over the best interests of a child be allowed to present evidence. Unfortunately, I was never informed that legal proceedings had commenced, and I had no notice of the court's involvement. In order for legal decision-making authority to be determined, both parents must receive notice, have adequate time to prepare, and be given the opportunity to present all relevant evidence. My case proceeded without adhering to these essential principles of due process. I was not given notice of the court's involvement, and I had no meaningful opportunity to be heard on this critical issue. Consequently, the court's ruling did not adhere to the requirements of due process. The Supreme Court has recognized that a parent's interest in the companionship, care, custody, and management of their child is among the most fundamental of civil rights. Therefore, before the state can deprive a parent of this interest, it must provide adequate notice and an opportunity to be heard. The failure to provide proper notice and an opportunity to be heard is a clear violation of due process. Stanley v. Illinois, 1972, 405 U.S. 645, 651, Lois R. v. Superior Court, 1971, 19 calories, App. 3D 895, 901. In my case, the guardian was aware of my whereabouts and could have easily obtained my address for notice. I voluntarily provided her with an address in September 2020 while awaiting a court hearing in Nevada. However, she made no effort to deliver notice to me, and she withheld information about my whereabouts from the court. This lack of notice and absence of any reasonable effort to find me cannot satisfy the requirements of due process. Insufficient or dishonest notice is equivalent to no notice at all. Furthermore, Rule 7.51 regarding the service of notice of the hearing on August 3, 2020, reveals a disturbing inconsistency. The guardian claimed that I was on the run from the police and could not be contacted, yet she also stated that I had been informed online and did not contest. This contradiction is deeply troubling. How could I contest if I could not be reached because I was allegedly evading the police, which I was not? The guardian's actions, including withholding information from me in the court, constitute a breach of my rights. Additionally, the guardian's actions may have violated several criminal statutes, including perjury, Penal Code 118, tampering with evidence, 18 U.S.C. Section 1519, and falsifying evidence. Her false statements and withholding of information influenced officers of the court and constituted obstruction of justice. I request a thorough investigation into these matters to ensure that justice is served and my rights are upheld. Christine's deceptive actions and abuse of legal processes are deeply troubling. She has made false statements to various parties, including Child Protective Services and therapists, to maintain her control over my children. She even fabricated events and conversations to justify her actions, further harming my reputation and credibility. The guardianship obtained by my sister is based on fraud and deception. She convinced the court that I willingly consented to the guardianship, even though I had never been informed or consulted about it. The court's decision to grant her custody without any prior communication with me is alarming and unjust. Additionally, I have uncovered information suggesting that my sister may have engaged in similar deceptive practices in the past, including concealing information from the courts and using fraudulent means to manipulate legal proceedings. In summary, the November 30th, 2020 hearing was marred by a lack of legal opportunity for me, concerning revelations in the reports, allegations of signature forgery, and unequal treatment of visitation rights. These issues raise significant concerns about the fairness and due process of the proceedings. Keep Lee to stop in her tracks and second the Guardian certainly. I have serious reservations about Mr. Quinones' conduct and actions in my case. I believe there are significant issues with his professionalism, impartiality, and integrity that warrant further investigation and scrutiny. I hope that these concerns will be taken seriously and addressed appropriately. In conclusion, my constitutional right to due process was egregiously violated throughout this case. I want to emphasize that this case extends beyond the termination of parental rights, TPR, or guardianship termination. It is a matter of justice, one that I firmly believe is unquestionably a criminal case characterized by child abduction, forgery, and fraudulent activities. I have sought justice through various channels, reporting the issues to the North Butte County Court, local law enforcement, Child Protective Services, CPS, justice centers, and even the FBI. Regrettably, I have been ignored due to Christine's legal guardianship. This case transcends TPR or guardianship termination, encompasses the violation of rights, rules, conduct, and human rights. It is a criminal matter, and I am determined to seek justice for my children and me. They deserve to have their biological mother and extended family actively involved in their lives, as was the case before this wrongful guardianship and forgery of legal documents without my consent. Despite her actions, this remains a case of child abduction as she fraudulently obtained guardianship by forging my consent. The legitimacy of her guardianship is not only questionable but highly dubious, if not outright fraudulent. I am resolute in my determination to fight for justice for my children and myself, regardless of the hurdles I have faced. I am deeply troubled by the permanent closure of the probate guardianship case. I had filed a petition for termination of guardianship before Christine Lure's retaliatory adoption petition, which was postponed nearly 10 times before seemingly being forgotten by the court. I kindly request your immediate attention and assistance in addressing this grievous matter. Your expertise and guidance are essential in navigating the complex legal terrain associated with this case. I eagerly await your response and guidance on the next steps we should take to rectify this grave injustice. I believe that justice must prevail, and my children must be reunited with their mother and family. Thank you for taking the time to read my plea, and I look forward to any assistance or advice you can provide. And I thank you for your unwavering support and commitment to justice. Michelle